Hello everyone and welcome back to Courts This Week by LiveLaw. I'm Debojeet and joining me as always is Advocate Awstika, who will walk us through the biggest legal developments of the week. From the Supreme Court stepping in after attacks on judges in West Bengal to concerns around illegal sand mining, key rulings on arbitration and corporate law, and even questions of free speech and media responsibility. It's been a packed week across courts. So without further ado, let's get started. 7 judges on duty, Gheraoed for hours by a mob in West Bengal's Malda. Supreme Court steps in, calling it a direct challenge to its authority. Awstika, walk us through what happened here.
Debojeet, the poll-bound state is seeing protests over deletion of names in the ongoing SIR exercise. In one such protest, 7 judicial officers who were actually deputed under Supreme Court's directions were surrounded for hours. Now the court has taken this extremely seriously. It said this wasn't just an incident of law and order, it was effectively a challenge to the authority of the court itself. And it was clearly upset that the state machinery failed to respond when sitting judges were under threat.
That sounds like a really chaotic situation. What did the court decide to do then?
So the court has now issued a series of directions. It has asked the Election Commission to deploy central forces wherever judicial officers are carrying out SIR work. Both the ECI and the state government have been directed to ensure that this process can function safely. It has also gone a step further. If any judicial officer has concerns about the safety of their family, that threat has to be immediately assessed and protection must be provided. Not only this, but the ongoing SIR process has also been regulated. Only a limited number of about 3 to 5 at a time can enter these premises where adjudication is happening. And importantly, the court has said that the investigation of the Malda incident must go to an independent agency, either the CBI or the NIA. Following this, in fact, the NIA has now been tasked with the investigation. A team has already reached Bengal according to reports. Meanwhile, the state CID is reported to have arrested the suspected mastermind behind the incident while allegedly trying to flee the state.
And there have been some other interesting observations by the Supreme Court too about what it thought of the state's condition.
Yes, it was quite a charged hearing. The court said it was disappointed that the Chief Secretary could not be contacted when judges were Gheraoed. Chief Justice Surya said he's never seen such a polarized state. There was also a pointed legal observation from Justice Joy Malda that voters who were added to the electoral rolls through Form 6 after the qualifying date will not get the right to vote in this assembly election, which has caused some public outrage. This week, the court also clarified separately that appellate tribunals set up under the SIR process can look at fresh documents as long as they verify the genuineness of those documents first.
And Oscar, there's also been some chatter around President's rule in Bengal in the backdrop of all this. How should we read what the court has said here?
Yes. And that's why this part becomes important. After the order was dictated, Senior Advocate Kapil Sibal asked the court to remove the line about a complete breakdown of law and order in the state, saying that this was an isolated incident and could be misread. Even though this faced stiff opposition, the court took note and in its final order, it toned down the language. Instead of a statewide breakdown, it recorded a complete failure of the civil and police administration in Malda district.
And of course, that distinction matters because this kind of language can carry wider implications. There's already political sparring around this, with Chief Minister Malda suggesting that incidents like these are being used to push a president's rule narrative. So it's evident why the court has been cautious in how it has framed these observations. Next, we have illegal sand mining on the list. The Supreme Court stepped in on a Rajasthan matter involving the Chambal sanctuary. What happened here?
So this is actually part of a suo motu case the Supreme Court has been hearing on illegal sand mining in the Chambal sanctuary, meaning the court itself took up the issue because of concerns about damage to wildlife and the ecosystem. Now what triggered this latest round was the decision by the Rajasthan government to denotify about 700 plus hectares inside the sanctuary.
Wait, so before we move forward, can you explain what denotification here means and what might be its consequences?
Of course. Very simply, denotification means removing the protected status of that land. Once that happens, restrictions go and activities like mining can be allowed. The Supreme Court was not okay with this at all. It said the state could not have done this on its own without coming to the court first, especially in a matter already under its scrutiny. So it has stayed the denotification for now, and the concern is very real. This is a fragile ecosystem home to endangered species like gharials, and there's already evidence of illegal mining happening there. The fear is that this move would have effectively legitimized or expanded that activity.
And there's also a worrying development from Madhya Pradesh linked to illegal mining.
Yes. And it shows how serious the issue has become. The Madhya Pradesh High Court has initiated suo motu criminal contempt proceedings against a sitting BJP MLA Sanjay Pathak for allegedly trying to influence a judge in an illegal mining case. And this denotification actually ties into a larger pattern we are seeing. Questions around how environmental safeguards are being handled or diluted. In that context, the post facto environmental clearance case we discussed last week has now been heard fully, and the Supreme Court has reserved judgment. The centre has told the court that post facto clearance is not automatic and that illegal projects can even be demolished. That ruling, when it comes, could really shape how strictly environmental violations are dealt with going forward.
Next, we have Byju's and its long run through the courts. This week, the Supreme Court seems to have closed one chapter of that story. So, what happened here?
So, this goes back to BCCI initiating insolvency proceedings against Byju's parent company over unpaid dues of around 158 crore rupees. The NCLT admitted the case, but later there was a settlement between the company and BCCI, or Board of Control for Cricket in India, and the NCLAT allowed the CIRP to be closed. The Supreme Court stepped in and set that aside, making an important point. Once insolvency is admitted, you can't simply withdraw it because one creditor and the company settle. After that, BCCI filed a review asking the court to reconsider this position and allow the settlement to effectively close the process. This week, that review has been dismissed.
So that means more or less a definitive nail in the coffin for Byju's.
That's what it looks like. It means the Supreme Court has effectively refused to reopen its earlier ruling. The court also noted that the review was filed with a delay of over a year and found no real grounds to interfere even on merits. So as things stand, the closure of the CIRP and the court's reasoning on how settlements work post-admission both stay intact. Technically, a curative petition is still possible, but that's a very limited remedy. So for now, this particular insolvency chapter between BCCI and Byju's more or less ends here.
This next one has implications well beyond the case itself. The Supreme Court laid down a very clear rule on company loans to directors.
Yes, and this actually came up in a very specific context. The case involved a director who used funds from his own company to meet a condition imposed by the Supreme Court while granting him bail, that is a 50 crore rupees deposit. The Supreme Court found that this money had effectively come from the company's funds without following the legal requirements.
And what are these legal requirements, and can you take us through these provisions too?
Yes. Section 185 of the Companies Act 2013 is the relevant provision. Very simply, this provision says a company cannot give a loan to its director directly or indirectly unless shareholders approve it through a special resolution, meaning 75% approval from shareholders who are the actual owners of the company has been secured, or giving of such loan is part of the company's ordinary business.
And from the looks of it, here none of these conditions were met.
Exactly. There was no shareholder approval, and obviously giving a loan to secure someone's bail has nothing to do with the company's business. Now, just to give you the background, the Supreme Court had granted him bail earlier, but on strict conditions. He had to deposit 50 crore from his own funds and make genuine efforts to settle claims of home buyers in this project. But over time, it came out that not only had he failed to settle those claims or hand over possession, there were also allegations of double allotments, and even insolvency proceedings had been initiated against his company. Despite multiple opportunities, the court was not satisfied with his compliance. And on top of that, it found that the 50 crore deposit itself had come from company funds. So the court treated this both as a violation of bail conditions and misuse of company money, cancelled his bail, forfeited that amount, and directed that it be used partly for public purposes and partly in the insolvency process.
Now, this one is interesting and yes, might be a bit technical. The Supreme Court has explained something called transnational issue estoppel in the context of foreign arbitral awards. Awstika, what was the core issue before the court?
The question was this: if a foreign arbitral award is challenged before the court at the seat of arbitration and that court rejects certain grounds raised by the challenging party, can that party then come to Indian courts and raise those exact same grounds to resist enforcement of the award here? The Supreme Court has said no.
And that's the transnational issue estoppel principle.
Exactly. Once a court at the seat of arbitration has determined a specific issue, that issue is treated as closed. You cannot relitigate it in a different country. The principle prevents what is essentially forum shopping, losing in the seat court and then trying your luck again in enforcement proceedings elsewhere. This is significant for India's position in international arbitration because it signals that Indian courts will respect the finality of decisions made at the seat.
And there's a related ruling on arbitration worth mentioning, correct?
Yes, you're right. And it fits into the same broader theme of finality. This week, the Supreme Court also held that if you abandon arbitration proceedings without getting express liberty from the court to refile, you cannot start fresh arbitration on the same cause of action.
That was our Supreme Court segment. Now let's move quickly through the top stories from other courts this week. The Rajasthan High Court made some observations on the Transgender Persons Amendment Bill of 2026 in one version of its order, and then later removed those remarks and uploaded a revised order. That's definitely an unusual move.
It's certainly not something you see every day. In the earlier version, the court had made some broader observations about the bill, which on the same day received presidential assent and became law. Those remarks, particularly on the impact of self-identification, were read as being critical of the legislation. They have now been deleted. The court clarified that its judgment has to be understood in the light of the legal position as it stood on the date of the decision, and the state must frame its policy within the contours of the law as it exists. So the court has essentially stepped back from making broader comments on the amended law and confined itself to the case before it. Naturally, this shift has drawn attention.
Next, we also saw Dr. Nemo Yadav's account on X or Twitter was blocked, and this week before the Delhi High Court, we finally got a reason. X says it was acting on the government's orders. But on what grounds?
X told the court that the block was based on directions from the Ministry of Electronics and Information Technology or METI on the ground that the account showed the Prime Minister in a bad light. And I have a feeling, Debojeet, that this framing is going to be central to the legal challenge. The question is whether this kind of content, which is critical of a political figure, crosses any legal line that would justify a blocking order, or whether that is state overreaching into free speech territory. And the Delhi High Court will have to engage with that squarely.
Next, the Delhi liquor policy case, which is still very much alive in the Delhi High Court. Where does it stand this week?
The ED has challenged certain adverse remarks made by the trial court while discharging the accused. Essentially, the trial court had said that agency like the ED cannot step in just on allegations of election funding irregularities without a clear underlying criminal offence. The ED says these observations were made without hearing it and could affect its ongoing investigation under the PMLA. Kejriwal and other respondents have not filed their replies yet. So the High Court this week gave them one last opportunity to respond. In terms of where we stand, it's still at the stage of completion of pleadings. Nothing on the merits has been heard yet by the bench of Justice Swarnakanta Sharma.
This one has a name that will make you stop mid-scroll. It's Pookie Baba. The Delhi High Court protected the personality rights of a religious figure who goes by that name.
The full name is Aniruddhacharya Ji Maharaj, a widely known and followed spiritual figure known popularly on social media as Pookie Baba. The Delhi High Court granted personality rights protection, which means others cannot commercially exploit his name, image, or public persona without his consent. Personality rights jurisprudence in India, for those who are unaware, is still developing. Courts, particularly the Delhi High Court, have been increasingly willing to protect public figures, religious and otherwise, from unauthorized commercial use of their identity and likeness.
The Allahabad High Court dealt with a situation in Bareilly this week around namaz being offered at a private residence. So what's the full picture here, Awstika?
So this case started with the petitioner alleging that he was being stopped by the police from offering namaz at his own home, which he claimed is a protected right under Article 25. On that basis, an earlier bench had taken a strong view, issued a contempt notice to local officials, and even granted him round-the-clock police protection.
That definitely sounds like a firm stance against the state.
That's what it looked like, but the matter then came before a different bench after a change in roster, which asked the petitioner not to hold large gatherings at his private property, even recording an undertaking to that effect. This happened after the state told the court that this protection was being misused, with large gatherings of 50 to 60 people taking place regularly, which could affect public peace. In addition to recording the petitioner's undertaking, the new bench also withdrew the earlier security and closed the contempt proceedings. It also made it clear that if there is any threat to law and order, the state is free to act.
Next up, Anil Ambani versus Republic TV in the Bombay High Court, and the court had something pointed to say to the channel.
Yes, this is a defamation suit filed by Anil Ambani over how the channel has been covering investigations linked to Reliance Group companies. The Bombay High Court made it clear that while the media is free to report, it cannot use disparaging language or sensational labels, telling the channel to not go below the belt and to tone down the rhetoric. The court was essentially drawing a line between fair reporting and commentary that creates a perception of guilt, especially when matters are still under investigation. And alongside this, Ambani is also involved in a separate case before the Supreme Court, where he's challenging banks classifying him as fraud based on a forensic audit into loans taken by Reliance Communications and other companies within the Anil Ambani group. That matter is expected to be taken up next week.
Staying in Maharashtra, where the 5% quota for Muslims in education has been scrapped, and that decision is now being challenged before the Bombay High Court.
The challenge is to a recent government resolution that withdraws a 2014 policy under which certain socially and educationally backward Muslim groups were getting reservation in education. The petitioners are arguing that this rollback is arbitrary and not backed by any data. This week, the Bombay High Court issued notice and sought the Maharashtra government's response. Viewers must note that this is constitutionally complex terrain, and the government's response will be key to understanding where this goes.
And then there was something about a Facebook post that called for a breaking of a Periyar statue that led to an FIR. The Madras High Court quashed it, but what was the legal reasoning?
The court held that the post was an expression of opinion and could not be treated as promoting enmity between communities under Section 153A or similar provisions. The court drew a line between offensive speech and speech that actually promotes communal disharmony in a legal sense. The threshold for criminal action on such posts is higher than simply being objectionable, and the court found this post did not cross that line.
And towards the north, the Allahabad High Court took aim, and it was quite literally at Uttar Pradesh's gun culture this week, both the old feudal variety and the new social media flexing variety. What did the court do?
The court has called for a complete arms license database across Uttar Pradesh, essentially asking the state to account for who holds firearms, how licenses are being granted, and whether the system is being properly regulated. What's interesting is the context. This came up in an individual case about delay in granting a license, but the court expanded it into a much larger issue, flagging how licensed weapons are being used to project power, build influence, and even for social media display. It has asked for detailed district-wise data, including cases where multiple members of a family hold licenses and where license holders have criminal backgrounds. So this isn't just about one license, as the court is clearly looking at how the larger pattern is playing out and how gun ownership is being exercised in practice in the state of Uttar Pradesh.
We close with an important acquittal in the Northeast Delhi riots case where Tahir Hussein's brother Shah Alam and 8 others accused have been acquitted. What have they been accused of, and what is the basis of their acquittal?
This case goes back to the 2020 Northeast Delhi riots and involved allegations of vandalism, arson and violence, damage to vehicles, shops and injuries in the area. Shah Alam, who is the brother of former AAP councillor Tahir Hussain, was among those accused. All 9 accused have been acquitted by the trial court, which recorded that the prosecution witnesses had deposed falsely and that it was unsafe to rely on their testimony. In these kinds of cases, eyewitnesses are usually the backbone. So once the court finds the testimony shaky, the entire case weakens. And that's what happened here. The accused were given the benefit of doubt and acquitted.
That's it for Courts this week. This is Debojeet Das signing off with Advocate Awstika Das. For detailed coverage of all the cases we discussed today, head over to www.livelaw.in and don't forget to follow us on all our socials to stay updated on everything that is law.